Sunday, June 13, 1971. The New York Times publishes the first installment of what it calls Vietnam Archive. Pentagon study traces 3 decades of growing U.S. involvement. The source was a government study officially titled United States-Vietnam Relations 1945-1967. Commissioned by Secretary of Defense Robert McNamara, it filled 47 volumes and contained roughly 7,000 pages of top-secret documents. A military analyst named Daniel Ellsberg, along with his colleague Anthony Russo, had spent nights in 1969 standing over a rented copy machine, duplicating those 7,000 pages. After approaching senators who declined to intervene, Ellsberg handed the copies to the Times. Printing those pages ignited an immediate confrontation between the executive branch and the free press. By Tuesday morning, the Nixon Administration struck back. Attorney General John Mitchell demanded a halt to the publication, and government lawyers rushed to federal court. This diagram shows the legal mechanism the government requested, a temporary restraining order to enforce a prior restraint. Unlike a prosecution after the fact, a prior restraint acts as a preemptive barrier, legally stopping a story before it can reach the public. The court granted the order, marking the first time a federal judge in American history had legally commanded a newspaper to stop publishing the news. This started a tense 17-day judicial clock. If the government could successfully use national security to silence a paper in court, it would establish a mechanism for executive veto over American journalism. The case landed in the Manhattan federal courtroom of Judge Murray Gurfein. It was his very first assignment on the bench, following his appointment by President Nixon. Judge Gurfein refused to grant a permanent injunction. He ruled that the Espionage Act of 1917 was drafted to punish spies, not to act as an instrument of press censorship. The government appealed. On June 18th, as the Times was blocked in court, the Washington Post began publishing its own copies of the study. The government sued the Post, and the consolidated cases moved directly to the Supreme Court. At the Supreme Court, the Times was represented by Alexander Bickel and Floyd Abrams. They argued against the government's chief appellate lawyer, Solicitor General Erwin Griswold. Arguments occurred on June 26th. 4 days later, the court issued its judgment, deciding the limits of national security without the customary months of judicial deliberation. On June 30, 1971, exactly 17 days after the Times published its first installment, the Supreme Court ruled 6-3 in favor of the newspapers. This diagram shows how the decision was actually structured. The court issued a brief, unsigned per curiam opinion, the box at the top, stating only that the government failed to meet its heavy burden of justification. Below that, the ruling fractured. Every single justice wrote a separate opinion. Justices Hugo Black and William O. Douglas argued for an absolute rejection of prior restraint. In their view, the First Amendment leaves no room for the government to stop the press from publishing news, whatever the source. A middle ground of justices acknowledged executive secrecy powers, but set the evidentiary bar exceptionally high. They ruled that the government must prove that publication would surely result in direct, immediate, and irreparable damage to our nation. The 3 dissenting justices pointed to the press withholding the documents for months before demanding an immediate judicial resolution. They argued the frantic timeline prevented the court from acting responsibly in a matter of national importance. The ruling established that the executive branch must prove a specific cataclysmic harm before the press can be silenced, a hurdle the government could not clear in 17 days. In 1991, the United Kingdom provided a comparative legal mirror in the Spycatcher case, which involved the memoirs of an ex-MI5 agent named Peter Wright. British courts successfully issued prior restraints against newspapers to block reports on the book's allegations. When the European Court of Human Rights evaluated the case, they looked at the restraints under the lens of Article 10. This scale shows the European proportionality test. It requires judges to weigh security against the public's right to know. The American First Amendment doctrine operates as a near-absolute barrier to prior restraint, making it distinct from this type of legal balancing. The Pentagon Papers case demonstrates that the American legal framework offers a protection from government censorship that favors the press over state secrets. Following the ruling, the government focused its attention on the source of the leak, indicting Daniel Ellsberg and Anthony Russo under the Espionage Act. In May 1973, federal judge William Matthew Byrne Jr. dismissed the charges. He cited gross governmental misconduct, including a covert break-in at the office of Ellsberg psychiatrist authorized by the White House. That illegal operation was carried out by the White House plumbers. This same unit's involvement in the Watergate break-in eventually became public, leading to the collapse of the Nixon presidency. 18 years later, in February 1989, Solicitor General Erwin Griswold, who had argued for the injunction, wrote an op-ed for the Washington Post titled "Secrets Not Worth Keeping." Griswold wrote he saw no trace of a threat to national security, concluding the government possessed no actual case for enjoining the press. The 17-day confrontation demonstrated that while the executive branch can classify thousands of pages, the American constitutional system relies on the scrutiny of a free press rather